Hello, my name's Steve Terrett, and I'm delighted to be joined in the BLC Box today by Rehana Azib. Rehana is a barrister who specialises in personal injury and employment law cases. She's the head of the employment team at the Chambers, where she's a member, which is 2 Temple Garden Chambers in London. Last year, she was named by The Lawyer as one of the top 3 busiest female juniors at the employment bar. So we're extremely lucky that she's managed to find time to talk to us. I'm very happy about that. She appears very, very regularly before the Employment Tribunal and the Employment Appeals Tribunal. And the tribunal system is something that, if it's not completely unique to the UK, then it's certainly very different to the regular court systems that exist throughout Europe. So I think you'll all find it interesting to hear something about that system. Rehana is also a bencher at Inner Temple, and she's the course director of Pupil Advocacy at the Inner Temple. She's co-authored the manual which is used to teach both junior and senior advocates and advocacy trainers. And she's taught advocacy in many countries throughout the world. And I'm happy and lucky to say that I've participated in some of those projects. So I've had the pleasure of seeing Rehana teach firsthand, and she's truly amazing. So Rehana, welcome to the BLC Box. Thanks so much for joining us today.
It's my pleasure. I just hope I can live up to that introduction.
You will. I have no fear about that. I'd like to start, if we could, by talking a little bit about your life as a barrister. I mentioned that you're a master of the bench, a bencher of Inner Temple. And Inner Temple is one of the 4 Inns of Court, alongside Gray's Inn, Lincoln's Inn, and Middle Temple. I just thought, maybe could you explain for our students what the Inns of Court are, and what role do they play in the life of a trainee or a practicing barrister?
Well, the Inns of Court are absolutely essential. There are 4 Inns of Court. So I'm a member of Inner Temple. We also have Middle Temple, Lincoln's Inn, and Gray's Inn. And you have to join an inn before you are called to the bar. You are called to the bar. That's your official graduation ceremony, as it were, to become a barrister. And then the inn is responsible for undertaking all of your mandatory advocacy training, both as a pupil and as a new practitioner, and all your mandatory ethics training. And thereafter, really, the inn is there to provide support, guidance, teaching, and the idea being that one day you then give back to your inn to the next generation of barristers by becoming advocacy trainer or serving on various committees. And they deal with developments in pupillage, monitoring pupillage, equality and diversity, education and training, anything that might affect the bar course, for example, and the training of barristers, and how all of that's regulated. So the inn plays an essential function. And after you've done all the mandatory bits, as it were, you can be as active or as inactive as you like, although many people choose to be very active in their inn.
And you're, I think, amongst the most active of the members of Inner Temple. You're a bencher of the temple. What does that mean?
Well, you become elected to bencher. It's really about serving your inn, contributing to your inn, and benchers sit on various committees. Effectively, they govern the inn, they govern the running of the inn, they control the staff, the students, the relevant policies that apply, any codes of conduct, codes of practice. So being a bencher means that you have direct involvement in voting for and setting policies and the running of the inn. So it's a great privilege. I'm very, very fortunate indeed to have been elected a bencher. I absolutely love it. And probably the best thing about being a bencher is that you get a special fob key, electronic fob, which opens a lot of secret doors in the inn. Don't tell them.
So did you always know from when you were a kid that you wanted to be a barrister?
Yes, I always knew. I always knew I wanted to be an advocate. I never had any fear of standing up and speaking in public and fighting my corner. I'd take every opportunity to do that, or I'd create an opportunity if I felt like it. You know, I was always pretty forthcoming, and it was just a natural fit. The law always interested me. I used to watch Perry Mason, Rumpole of the Bailey with my parents and thought, oh, that looks like fun. I wouldn't mind having a crack at that. And it was the advocacy element that appealed to me the most. You know, the idea of standing up and speaking and arguing and questioning witnesses never frightened me. It excited me. It thrilled me. I wanted to do it. I couldn't wait to do it. It still excites me. It still gives me great pleasure. I still look forward to doing it.
Do you have nerves or a tingle before you go in and do advocacy now, even though you've done so much of it?
You have a sort of adrenaline rush, and you have nerves. It's sort of nervous excitement. I guess the closest comparison is when you're queuing up at a theme park to go on a roller coaster. So you're nervous and sort of scared, but that's part of the fun. That's what makes the experience so thrilling. And you've got the adrenaline pumping, and you know it's going to be a great ride, and there's going to be ups and there's going to be downs. But afterwards, you're going to have loved it and want to do it all over again. And that's probably how I feel. And I've always said that the day I don't feel nervous or feel an adrenaline rush or feel any butterflies is the day I stop doing this job, because it's the day I've sort of stopped caring, stopped feeling any passion about it.
Excellent. I love the analogy of the roller coaster. What would you have been if you weren't a barrister, do you think?
I don't know. That's a really interesting question. So I guess something where I could speak, because I do love the sound of my own voice, even if others don't. Something where I could perform. But not necessarily acting. Acting never appealed to me, and I'll tell you why it didn't, because to me it wasn't an intellectual enough challenge. Because actors are scripted, and I didn't want to be scripted. I wanted to write my own script, and I wanted an intellectual challenge. Perhaps something to do with psychology, which might sound bizarre, but actually, when it comes down to it, the law is ultimately about people, about governing people's relationships with the state, people's relationships with each other, and particularly the sort of areas that I do, you know, discrimination, harassment, bullying, stress at work, are all about people's relationships and interactions with each other, why they behave the way they do, what motivates them, how people will behave when you question them, how they behave in court, how they come across. It's all to do with psychology, really. It all boils down to psychology. And I think you can't really do this type of work in particular if you don't have an interest in people and how they think and how they act.
Our students sometimes ask us, in practice, what's the difference between the working life of a solicitor on the one hand and barristers on the other? So what would you say to them?
It's a common question, and actually quite sort of difficult to answer, because there are subtle differences and large differences. I think the starting point is, what's the ultimate difference? And the ultimate difference boils down to advocacy. Our role is really about being the advocate, and whether we're involved at the very last minute on the eve of trial or at the start of litigation, our mission statement is clear. We've got an eye on what's going to happen at trial when we have to stand up and argue the case. So all of our work is around advocacy, preparing experts, drafting, doing advices as to whether we should fight or not, advising on witnesses, advising on evidence, that sort of thing, and a lot of advocacy. And I think solicitors have more of a sort of day-to-day advisory role without necessarily having that advocacy aim, as it were. And barristers are self-employed, so we're less regimented. Our lives, day-to-day lives, are dictated by the work. But I think in terms of the hours that we work, it's very, very similar. But for example, where a solicitor might be advising on a policy, writing an employment policy for an employer, or advising on a contract, etc., my work is more about the litigation side of it, potential claims, actual claims, managing them.
solicitors, they would work in a solicitor's office. They're employed. But you mentioned about chambers. And again, this is one of those concepts where sometimes I, as a teacher, struggle to try to explain to students exactly what chambers are. You're members of them, but not employed by them. There are clerks. Help me to explain this to students. What's going on with chambers?
Yeah, okay, I shall do my best. Effectively, chambers is a collective of self-employed barristers who are self-governing and self-regulating within that chambers. That means they set their own chambers policies, they run their own chambers, and they fund their own chambers. So they may rent premises from the inn. So for example, we're based in 2 Temple Gardens. That's my chambers, and that's also the address. We're based in the inn, so we rent our chambers from the inn. And the barristers would pay a proportion of their income to the running of chambers. So all the administrative costs of staff, etc. So we're self-governing, self-regulating within the chambers environment. Now, our clerks, I guess, to use another analogy, because I think analogies are almost always helpful, they're like our agents. Okay, so if I was an actor, for example, I would have an agent, and my agent would go out and try and secure work for me. My agent would negotiate fees, terms of the contract, etc. And that's what they do. And they also sort of have an element of being a PA. And I don't say that to denigrate in any way what they do. Being a PA is a wonderful job if you've got the temperament for it. A lot of people don't, but it's also about juggling the diary, managing commitments, making sure that we can manage everything we're tasked to do, juggling things around, securing work, negotiating fees, maintaining relationships with solicitors, making sure we have the papers that we need on time, making sure we know where we're supposed to be, which court we're in, which judge we have, and collecting fees as well. So I guess there's an element of debt collection in there too.
An agent with a baseball bat.
See, barristers don't get their hands dirty in that respect. We don't get involved directly with the client when it comes to negotiating fees or collecting payments. We don't do any of that. We leave that to the clerks. They're much better at it anyway.
Well, within chambers, you're the head of the chamber's employment law group. And although you deal with a large range of cases, then I think would it be fair to say that employment law is the one that it would keep you the busiest, and it would be your largest area of expertise?
Probably, but the split between my work is probably 60% employment and 40% personal injury. But a lot of the personal injury work I do is like crossover employment work. So I do a lot of employers' liability personal injury. So anything that happens in the workplace, whether you're bullied, whether you suffer an injury, you have stress at work, someone's harassing you, discriminating you, and often a lot of the claims I will run concurrently in the employment tribunal jurisdiction and in the county court, or in the High Court, and it's this dual expertise isn't particularly common at the bar, because people tend to practice almost exclusively in employment or practice in employment and commercial. So you don't actually get many people that practice in employment law and personal injury, and it always surprises me because they're such a natural fit together. There are so many overlapping issues. But that's really sort of what I do. So whilst I do a lot of employment work, a lot of the employment work also leads to personal injury work, or the personal injury work will lead to employment work. Okay. So it's very much a sort of dual practice.
In terms of the areas or the types of disputes that then commonly arise within employment law, then are there some kinds of disputes that are more common than others? And which law would apply to them? Could you give our students, like in a nutshell, what the law of employment looks like in the UK?
Sure, that's a tall order.
I wouldn't ask anyone else to do it, but I just know basically you're going to be doing our jobs for us here at the BLC for the next couple of months. So we owe you something.
You promised me no difficult questions. Okay, I will do my best. I think it depends on what the climate is at the time. And I say that because a few years ago, I was doing a lot of whistleblowing claims. And for those people that don't know, whistleblowing is effectively where you're making a sort of disclosure of information that goes to someone potentially committing a fraud, health and safety, for example, putting patient safety at risk, that sort of thing. And it's where you bring that concern to your employer's attention, and then you're subjected to a detriment because of it. For example, you don't get the promotion that you know you deserve because you're seen as a troublemaker, or you're subjected to a sham disciplinary process. And the law on whistleblowing has evolved quite a lot, in particular, the definition of what actually amounts to what's called a protected disclosure. You know, when does a disclosure of information or an employee saying, I have this concern, become protected at law? I also noticed that when the compensation cap was introduced for unfair dismissal claims, pure unfair dismissals, there was a sudden increase in unfair dismissal claims that were also linked to discrimination. And not to be too cynical about it, but I don't think it's any coincidence that if you have a discrimination-related dismissal, there is no compensation cap. Whereas if it's a straightforward unfair dismissal, not to do with any form of discrimination, there is a compensation cap of 1 year's loss of earnings. And the trend more recently, particularly in the last 2 years, is more what I'm seeing, harassment. So harassment under the Equality Act. And under the Equality Act, harassment is the kind of behaviour that violates someone's dignity, that is humiliating, is offensive, and it has to be linked to a protected characteristic. So it's got to be on the grounds of something like race or religion, gender, things like that. Political belief, that's an interesting area that's also expanding.
Does anyone believe in politics anymore?
Yeah. Well, the climate change is a protected philosophical belief.
Oh.
I've done a few cases recently about whether nationalism is a protected belief, because one of the criteria that determines whether something is a protected belief, particularly for a philosophical belief, is that it can't be incompatible with the values of a democratic society. So some branches of extreme nationalism may well be incompatible because they interfere with the freedoms and rights of others, such as, religion, and race, etc. But harassment is a really common one at the moment. If you bring a harassment claim in the employment tribunal, it doesn't matter how egregious the conduct is, if you can't link it to a protected characteristic. So if you can't say this behaviour was because of my race or because of my gender or because of my religion, the claim can't succeed. And this is where the crossover claims come in, because we also have the Protection from Harassment Act. Now, the Protection from Harassment Act, it's not something that the employment tribunals have jurisdiction over. That's something that's dealt with by the county courts and the High Court. And that is harassment that doesn't require a protected characteristic. If the conduct is sufficiently serious, you don't need to link it to race, etc. And sometimes people will make claims under both. It's more difficult to argue harassment under the Protection from Harassment Act because it's such a high standard. It's effectively the kind of conduct that might attract a criminal sanction. Indeed, it can attract a criminal sanction because under the Protection from Harassment Act, you can be imprisoned for up to 6 months. And you need to have a course of conduct. So one really bad act won't cut it. You've got to have 2 or more acts of harassment, which each individually reach that threshold. So harassment is a hot topic at the moment, and it's not just litigation that I'm dealing with, but pre-litigation. So advising on investigations into harassment and how they should be done properly, or conducting investigations, being an independent investigating officer. So really, in terms of what's hot in employment law, there's ebbs and flows, there's tides, and the tide at the moment is all about harassment, which probably doesn't come as a surprise in the wake of Me Too and Time's Up.
Absolutely. You mentioned there an independent investigator for harassment claims. Are these kind of investigations, are they always done by an external independent body, or are they sometimes done internally?
No, in fact, they're predominantly done internally, but sometimes you might have an investigation that's particularly serious, or that requires some degree of legal expertise. Or you may find that you've got an individual raising complaints against a lot of senior managers who would ordinarily be the managers conducting the grievance. And in order to ensure the independence, employers will often come to solicitors or even barristers to act as independent investigators, because we would have the employment law experience, but we also have litigation experience. And of course, an investigation is never conducted with an eye on litigation, because your function as an investigating officer is just to investigate and see whether the allegations are proven or not. But having the benefit of experience of doing so many years of tribunal claims, you understand, you know, what the strengths and weaknesses are of investigations. You understand when investigations are bad, why they go bad, what's done wrong, what's deficient, what's done well, what do I need to do, what do I need to cover. And I think that experience is really, really helpful, particularly when you're dealing with quite high-level investigations against very, very senior employees, if not the most senior employee in an organisation. It's a huge responsibility.
Do you have a preference in terms of whether you're acting on behalf of the claimant, the employee, or the employer?
My work is predominantly acting for the employer, and that's just the way that my practice has evolved. So I would probably say about 95% of my work is acting for the employer. And of course, the more you do, the more experienced you become at representing employers specifically, which attracts more instructions. But I have to say that I probably do prefer it, and I prefer it for this reason. When it comes to representing an employer, yes, there are considerations, commercial considerations, reputational damage, adverse publicity, particularly some of the clients that I have if I'm representing. For example, you know, multinational companies, international charities, and solicitors' firms. I often get instructions to represent solicitors' firms for their own claims, so there's a big reputational factor. But at the end of the day, it sort of comes down to money, really. And, you know, even if you get an adverse decision, the employer can live with it. They learn from it. They can amend their internal processes. They write a check and they live to fight another day. But I think for employees, particularly those that have been seriously discriminated against and have resigned, or they've lost their job and they've suffered personal injury as a result, like, you know, lasting psychological or psychiatric consequences, it is everything. It's their entire life, and the stakes are higher. And even if they succeed and get a compensation check at the end of it, it's still not a full answer to the problem. And so you have an additional emotional responsibility to a claimant in what's already a very stressful job. So I think I probably prefer acting for employers, but I do act for employees. I'm happy to act for employees. And actually, I can bring the benefit of my experience, my years of experience acting for employers, when I'm representing employees.
You mentioned that certain claims are dealt with in front of the employment tribunal, and then other claims in front of, let's say, the common courts. The whole idea of a tribunal system is something that is, I'm genuinely not sure whether it's only in the UK, but it's certainly not in most of the countries where the British Law Centre teaches. So could you maybe explain to us what is the idea behind having a tribunal system, or why do we have tribunals instead of courts, and how do they differ from the regular courts?
It's sort of designed to be a more accessible form of justice, I guess. I mean, that's what it was created and designed for. So it's less formal than going to the county court or the High Court. You're not robed. You're not paying huge fees to issue a claim and then to have your claim heard, a hearing fee, although there was a period when fees were introduced and eventually they were overturned following a decision by the Supreme Court, following a challenge that was launched by the trade unions because it impeded access to justice. But people can represent themselves in the employment tribunal. That's what I mean by accessible means of justice, access to justice. But more than that, employment disputes aren't just about the law. They're not about clever legal arguments and technicalities. It's about people. It's about the realities of a workplace, the realities of managing people, people's day-to-day working relationships, working processes. And the huge advantage of an employment tribunal is that for discrimination claims and for whistleblowing claims, you would have a panel of 3 members. For things like contractual disputes and sort of standard unfair dismissal, you'd have a judge sitting alone. But for the majority of claims, you would have a panel. And the panel comprises of a judge who's legally qualified and 2 lay members. And out of the lay members, one of them will have staff side experience. For example, they may have had several years as a trade union representative, so can give an employee perspective. And the other lay member will have management side experience, so they can give the employer's perspective. The idea being that they have real and practical experience of the workplace and the sorts of standards to be expected and what is consistent with reasonable standards. So it's almost like a quasi-jury, I suppose, and they have some knowledge of the law, but it's really the judge who's the legal expert. And each of them gets an equal vote. People are often surprised by that because they think, oh, well, because the judge is legally qualified, it must be the judge that dictates it and the other 2 follow. And that's not true. It's rare to get split decisions, but you can have them. And I remember a case years and years ago that I was involved in, where it was a 2-1 decision where both panel members disagreed with the judge. And no one person gets a greater vote than the other. So it's quite an interesting dynamic, but I really like it because it also affects, I think, your style of advocacy.
Okay.
I think your style can be different when you're addressing a judge by themselves to when you're addressing a panel member. And for example, when you're sort of making technical legal arguments, and this is certainly no insult to the intelligence of panel members who are hugely intelligent and hugely experienced, but whereas if I was addressing a judge, say in a closing speech in the High Court, it'd be very technical and more heavily focused on the law. I introduce more of a human element in my closing speech to a panel because I'm addressing 2 lay members. It's not quite the jury advocacy that you see in the criminal courts, and certainly not what you see on TV. But there is an element of saying, look, how am I going to make my submissions more attractive and more accessible to 2 people that have knowledge of the law and have experience of the law, but aren't legally trained and legally qualified? And you can introduce more of a human element, more emotion into it, than I guess you would do if you were just addressing a judge alone, because you've got to appeal to them as well as appeal to the judge.
I can already hear your incredible advocacy experience coming through, and I do really want to talk to you about advocacy training. But just before we move to that, there's a few other issues about the employment tribunals and employment law that I'd like to just touch upon briefly with you. One thing that sometimes our students find strange in the English legal system as a whole is the idea that there is no automatic right of appeal if you lose a case. It's the gift of the judge, or almost. Is the same situation found in employment tribunals? So if someone loses a case at first instance, what happens if you want to appeal?
Well, there is certainly no automatic right of appeal. And I don't think there should be an automatic right of appeal, because it's almost as if you're sort of setting it up for your judge or your panel to say, look, whatever you decide, anyone who wants to can automatically appeal, whether they've got a good basis or not. But anyone can appeal, but it's subject to strict limitations. And there's a two-tier system. So you would submit your grounds of appeal to the Employment Appeal Tribunal, and there is a paper sift. So a judge or registrar would look at your grounds of appeal on paper and make a determination. Now, they might determine on paper that you have valid grounds of appeal and give you permission to appeal, in which case you would then proceed to a full appeal hearing. They may give partial permission, or they may refuse permission. If they refuse permission, the appellant can make an application for what's called a Rule 310 hearing, and this is an oral hearing where they can appear before an EAT judge and seek permission to appeal by making oral arguments, so argue their corner.
Okay.
And following that, either the judge will decide, well, I'm still not giving you permission to appeal, or I'm going to give you permission, or I'll give you permission to appeal on some grounds and not others. So it's a good two-tier system, I think, because it strikes the balance between sifting the meritorious claims from the unmeritorious claims, so you're not clogging up the system with unmeritorious appeals. But it also gives people a second bite of the cherry. So if they think that there are arguments they would have liked to expand on, because your grounds of appeal is supposed to be a pithy document, you know, it's not supposed to be a detailed narrative or diatribe as to why the decision is wrong. But sometimes actually having the opportunity to stand and argue why you're saying this decision is wrong can make a judge look at it in a different way, or can clarify what may not have been readily apparent from your grounds of appeal. So I think it strikes a really fair balance, but I'm certainly opposed to having an automatic right of appeal, because I think that parties should be encouraged to seriously consider whether there are valid grounds for appeal, and not simply appeal and take advantage of their automatic right because they're not happy with the decision. Somebody is always going to be unhappy with the decision, but that doesn't mean that there is a valid ground of appeal in there.
And in those cases where appeal leave to appeal is granted, are they appeals about, should we say, questions of fact about who did what, who said what, or are they appeals about what the law means and more legal questions?
Predominantly, they're on matters of law. You've got to be able to show that there was an error of law. But you can make a factual challenge via what's called a perversity appeal. But the threshold is extremely high because you've got to show that the decision reached on the facts or the evidence was a decision that no reasonable tribunal could have reached with the same evidence and facts before it. And that is actually a high threshold. You've got to show an overwhelming case. So it's not enough even for the appeal judge to say, well, I disagree with that decision, I wouldn't have made that decision. There has to be an overwhelming basis to overturn the decision, particularly because the appeal judge doesn't have the advantage that the tribunal panel has, which is hearing evidence, reading all of the documents, seeing the witnesses, assessing their credibility, and assessing their demeanour and their body language to form a view as to their credibility. So you can challenge a decision on the facts on the grounds of perversity, but it's rare to get permission to appeal on it because the threshold is high, and even rarer to succeed on it because I think the Employment Appeal Tribunal recognises that there can often be a spectrum or a range of opinions that a tribunal can reach on a particular set of facts. It's very rare, if it happens at all, that one set of facts and evidence leads to one inevitable conclusion and no other. So really it's about, does the decision, whether I agree with it or not as an appeal judge, fall within that spectrum? Or is it so far outside the spectrum that no reasonable tribunal could have come to that conclusion? But it's predominantly errors of law. Although the errors of law and the appeals that I've sort of fought and brought on errors of law do inevitably come down to facts and evidence, because of course if you're challenging the application of the law or the application of the legal test, or saying, well, the tribunal didn't apply the right legal test to the facts, or they misapplied the test, or they placed the test too high, you have inevitably got to look at the facts and the evidence, because that's your starting point. Before the tribunal applies the law, they've got to establish the facts. So it's inevitable that in any appeal, no matter how technical on a question of law, is going to go into the facts and the evidence and the factual findings of the tribunal.
Would it be usual for you or for other lawyers who dealt with this case at first instance to also keep it and deal with it on appeal if it is appeal? Yeah? Yes,
it would be normal unless you were unavailable for some reason, or there might be a reason why you would have to recuse yourself. For example, if there was an allegation that you as a barrister behaved improperly, you would effectively have to address that and give evidence on that.
Okay.
At the appeal stage, and you can't give evidence and be the advocate for the party. Okay. But absolutely you would, because it's been your case. You understand the case better than anyone coming in. And I've had a couple of occasions where I've been asked to come in on the appeal, and it's much more difficult being parachuted in to somebody else's case when you don't know all the ins and outs of it, and you weren't there. You weren't there at the tribunal, so you don't know how the evidence came out. You don't know how the witness performed under cross-examination. Did they make any howlers in cross-examination? Or was a particular argument properly pursued by counsel in the first place? Because, you know, if one of the grounds of appeal is, well, the tribunal didn't properly address this particular argument that I made, I would be asking myself, well, was that argument made, or was it made properly at first instance? Because if it wasn't, then it's unfair to criticise the tribunal for not dealing with an argument properly. They have to deal with the arguments as they are put before them.
Now that, I shall try my interviewee skills by seamlessly weaving together one topic into another. But what you've raised there is the question of the advocate's performance during the trial. And I mentioned it in the introduction that you are a senior advocacy trainer for Inner Temple. And you're the director of the Pupils Advocacy Training Programme at Inner Temple. And I know
am alongside Master Alistair Hodge.
Absolutely, who has also been with us in the BLC Box recently. So yes, we're very, very happy to not just to have welcomed you to the BLC Box, but to have seen the advocacy training in action. But for those who haven't seen it, and for those who may come from a country where there's not so much emphasis on advocacy training per se, it's still expected that you will learn this as you're doing the job. Then could you just say a few words for us about the approach of the English bar and Inner Temple in particular to advocacy training? Is it theoretical, practical? What does it look like?
Probably a little bit of both. More practical, I'd say, than theoretical, but theory definitely has its place. And it's sort of a relatively new concept. I say relatively new, probably sort of coming in the last 2 decades. So decades ago, there was no form of advocacy training for barristers, mandatory or otherwise. You learn by doing. You made your mistakes on the job, you watched other people, and you just did it, and you made your mistakes, you live to fight another day. Hopefully you learn from them, and hopefully you get better and better. And there was this ethos that advocacy couldn't be taught, that you're either a good advocate or you're not, and you can't teach someone to be a good advocate. Now, that has all changed mercifully. So mandatory advocacy training for pupils and for new practitioners was introduced, certainly when I came to the bar 17 years ago. It was in place and had been for a few years before then. And what we try and do is sort of teach you all the skills around doing your advocacy. What do I mean by that? Advocacy isn't just about standing up and doing it. It's all about the preparation that leads up to that. So we teach you a sort of multi-stage approach from beginning to end. So when you get a case, how do you analyze the case? How do you analyze the strengths and weaknesses? How do you decide what arguments you're going to raise? Okay, analyze your case, and then you know what your roadmap is for your case. And from that, you know how you're going to argue it. You can decide which witnesses you're going to call, what you're going to question witnesses on, how you're going to question them, and what you're going to say in your closing speech. And within that teaching, we also teach you about skeleton arguments, how to do good written submissions that are succinct, that are consistent with your case analysis and your case theory, that are persuasive. So it's about advocacy in writing. And then how to do performance advocacy. And that will be submissions. This is speeches, whether it's a closing speech to a jury, or it's a plea in mitigation, or it's a closing speech to a judge, or you know, an application that you're doing on a legal point if you're applying for an injunction. And we teach witness handling. So how do you take evidence from witnesses in chief? What makes good evidence in chief? You know, what tells a good story? How to cross-examine witnesses and how to tie it all together. So there's the theoretical and there's also the practical. But we do recognise that a lot of the time you learn from doing. Mm-hmm. And you learn from seeing other people doing. So you've seen this yourself in terms of the method that we adopt, the Hamper Method. It's very much about getting the pupil or the new practitioner or the student to perform a piece of advocacy. Let's say it's cross-examining a witness. And the advocacy trainer will analyse that performance and will pick one point, what we call the headline point. So you focus on one point, one area to improve, and we identify that to the student in our feedback, and we explain it in a way that never used to happen on the job. We say, look, this is why the way you're doing it might not be effective. These are the potential problems with it. And then, crucially, we tell them how to make it better, how to improve their performance, what's called the remedy. This is what you need to do in order to make your performance better, make it more effective, to address that particular problem. And the remedy might be in terms of how you prepare the case. It might be in terms of the words that you're using or the types of questions that you're asking. So we'll give a practical solution so that when you do it next time, you will know how to do it better. And then the bit that puts the fear of God into advocacy trainers, we give a demonstration, which is mercifully short, but we demonstrate what we've just said. So whatever remedy we've given, how to make it more effective, and this is why it's more effective, we then stand up and we show them our theory in practice. And the idea is that they watch us doing it, it draws it all together. So they don't just have the theoretical lesson, they have the practical lesson. And you just pray to the heavens that you don't make a mistake in your own demonstration. Although if you do, you can use that as a learning tool and to say, look, did you see what I did there? Did you see how I got it wrong? And I probably could have done this to make it better. It makes you more human. And then the student gets the opportunity to have another go. So maybe redo that particular part that you've identified. And we do that consistently over the course of several weekends with different exercises. So by the end of it, the pupils have a number of different lessons for different aspects of advocacy, whether it's submission advocacy, application advocacy, whether it's cross-examining witnesses. If it's the new practitioners, it's cross-examining expert witnesses, or perhaps doing an element of appellate advocacy. And so it's really a combination of the two, practical and theoretical. But you can make good advocates, you can teach advocacy. And you'd be amazed at the improvement that you can see over the course of a weekend when you're teaching people. And you know, Steve, I've had the pleasure of teaching with you and with Ruri, and you've seen over the course of 2 or 3 days how much of an improvement we've seen in the students that we teach. And it's wonderful. It's absolutely wonderful. It's so satisfying. It's so rewarding. And it just proves that you can teach advocacy. You can teach people to be good advocates.
Absolutely. Well, I'm about to breach one of the golden rules of advocacy.
Against my better
only ever
advice.
ask a single question. So I'm going to throw a couple of questions in together, which is,
Okay.
in your experience then, what would be the, should we say, the most common problem that new advocates show when you're seeing them? And how do you go about resolving that problem for them? What advice can you give advocates?
it's quite difficult because, you know, your mission can be different depending on what type of advocacy that you're doing. So you tend to have common problems cropping up, particularly in cross-examination, or particular problems cropping up in submissions advocacy. But I'd say there is a common theme that tends to be, whatever the sort of surface problem, I think, in my view, it almost always comes back to how you're preparing the case. And focus. You don't have to challenge every point. You don't have to take every point. You take your best points. And it's really about focusing your attention in your advocacy. So longer is not better. Talking for longer is not better, whether you're questioning a witness or whether you're doing submission advocacy. And it's really about shortening what you do to only do what is necessary to make your case and no more. So in submissions advocacy, you might advise somebody to make their speech a bit crisper, to get to the point a lot quicker. Don't sort of do a long introduction about all the things you're going to be saying in your speech. Just go ahead and say them. In a cross-examination, don't ask a whole host of questions around matters that are completely irrelevant to the jury or irrelevant to the judge and don't make any difference either here nor there. Focus on the issues that you need to get the evidence out on. So that's probably a sort of common theme, I would say, that I see. But there is one thing I will also say about advocacy training generally, and I think it's an important point. It's not about producing advocacy robots. It's not about producing a whole generation of advocates that talk the same and look the same and act the same and do everything in the same way. Advocacy is very much about your own personal style, and everyone has a different style, and no one style is better than the other. It's about teaching you to be true to yourself. So as an advocacy trainer, what we do is we sort of identify and look at what type of advocate this person is, and it's about making their own type of advocacy better, not turning them into the kind of advocate that we are. So there are some people, for example, that do really well with a more aggressive style of advocacy. But there are other people who have a gentler disposition and a gentler voice. That doesn't make them any less effective or any less persuasive as advocates. I say to them, you're going to be the silent assassin. No one's going to see you coming. You're going to kill the witness with politeness. And whilst you're going to be smiling at them, you're the smiling assassin. The whole time you're handing them the rope, and they're tying the noose around the neck and hanging themselves, and they have no clue because they just don't see you coming. There's no one right style. So I think it's really important tonight. I think I say this because it's a common concern that I've had with students, new practitioners, even established practitioners that are saying to me, but I'm not like you. My personality isn't like yours. My style isn't like yours. I can't do it that way. And it's about saying to them, I'm not telling you to do it exactly like Rehana would do it. I'm giving you the tools that you can then apply your own style to. Do it your way, but it's the method that I'm teaching you, not the style.
Well, as you mentioned, we've been fortunate enough to see you teaching students, and in addition to teaching the style, one thing that really struck me was just how much fun people found it, because at the beginning of the training, everyone is very nervous and feeling that this will be a judgmental, horrible experience. And yourself and the other members of the Inner Temple Advocacy Training Squad, the Jedi Council of Advocacy, you have a wonderful way of making people feel at ease and enjoy it, as well as improving their advocacy skills. So I highly recommend, if ever anyone does have the opportunity to participate in any advocacy training, either by Rehana or by the Inner Temple, I could not recommend it more, because it's absolutely fantastic experience. Which also involves, you mentioned the silent assassin. I won't betray any secrets.
That's really kind of you.
I recall Batman figuring in one of the sessions that we did, as well as Gladiator. So I won't betray.
As well as Gladiator. Yeah,
exactly.
that's a teaching tool that I think is unique to me. It's certainly not in, I didn't write that into the Inner Temple Advocacy Training Manual. But actually, I have to say, Steve, that teaching method, and I'll explain in a minute what it is, was inspired by the advocacy training that I had to do. It's not like you were holding a gun to my head and forcing me to do it. It's an absolute pleasure. But that I did with you and Rory, because the added factor in advocacy training for the projects that we were working on together was the language factor. Now, it's easy for me to do advocacy in English, train advocacy in English, because it's my native tongue. But for the students that we were teaching and some of the lawyers that we were teaching, and even some of the judges, English was their second language. Now, advocacy is difficult enough because it requires a sort of mastery of the language. It's difficult enough doing it in your native language, let alone doing it in a second language. So I had to find a way of communicating with the students and with the lawyers to try and overcome the language barrier, and not only create a safe and fun space, but also to try and convey things about style, about presence, about how you own your space in the courtroom and make an impression that are actually quite difficult to put their finger on. So I thought to myself, what's the one universal language we have the world over? It's films. So I thought, why not use a film as a teaching tool? And there are particular moments in films and particular speeches that resonate because of the way they're delivered by the actor, and because of the words that are used. So we developed, you remember, the Gladiator speech that we used, and this is where he reveals his identity to Joaquin Phoenix. And, the iconic speech, "My name is Gladiator, father to a murdered son, husband to a murdered wife, and I will have my vengeance in this life and the next." And I thought, get the students to watch that speech and think about what makes it so powerful, not just the words, but the way it's delivered, the expression, the body language, etc. And similarly, there's a speech in The Dark Knight. It's at the end of The Dark Knight, and it's where Batman's running away, and it's Gary Oldman's voiceover, about him being a dark protector, being the hero that Gotham needs right now, etc. And then what we did, you'll recall, is that we actually wrote out a few lines of that speech, and we practiced it as if we were Gladiator, as if we were Gary Oldman giving that speech, doing it in our own style, not having to worry about language or worry about what to say because the script was there. It's about loosening people up, relaxing them, getting them comfortable with the language, but also allowing them to experiment with the manner in which they deliver it, in the hope that once they get comfortable and they see what sort of style works for them, and they feel confident enough to experiment, they can then apply that same style to the advocacy that we were doing. So you and Rory and your teaching projects were definitely the inspiration for that, but I found it to be a very, very effective teaching tool on teaching the kind of things you can't quite often put your finger on in terms of presence and owning your space, but also very effective if people aren't feeling confident in language.
Exactly. I will always remember it fondly and look forward very much to the next time when we are able to meet, not just, hopefully not mask to mask, but face to face, not through Zoom. It's been, as always, an absolute pleasure talking with you. I'm very conscious that I should probably let you go because I know exactly how busy you are, and I'm really glad that you've been able to find time to talk to us. It's been really educational, really informative, and really great fun talking to you again, Rehana. So thank you very much.
Thank you so much for asking me. Thanks so much. Take care, and hopefully I'll see you soon in real life.
Bye-bye.
Take care. Bye.